Swayam Prabha. Digital India. Educated India.
Welcome to the second lecture of the subject Business Law on the topic Introduction to Contract and Essentials of a Valid Contract Part 2. I am Dr. Rama Bansal, working as Assistant Professor at Arya College, Ludhiana. This project is sponsored by DTH Swayam Prabha, MHRD, New Delhi. In this chapter, we are going to cover the various essentials of a valid contract. In our previous lecture, we have covered the first two components, that is offer and acceptance and the legal relation. In this chapter, we will cover the another three components named consideration, capacity of parties and free consent. Let's start with our presentation. I am going to cover the third component, consideration. We are discussing the various essentials for a valid contract. Among those essentials, the third one is the consideration. First of all, it's important to know that what is consideration. According to Pallock, consideration is the price for which the promise of other is bought and the promise thus given for value is enforceable. If I talk in very general terms, consideration means something in return. When a contract is made, there should be some consideration in return for that promise made by both the parties. Section 2D of Indian Contract Act also defines consideration as when at the desire of the promiser, the promisee or any other person has done or abstained from doing or does or abstained from doing or promises to do or abstain from doing something, such act is called a consideration for the promise. Let's take an example. A promises to maintain B's child and B promises to pay rupees 20,000 yearly for this purpose. Here the promise of each party is the consideration for the promise of other party. A has promised to maintain B's child, and for that consideration, for that thing, he is getting rupees 20,000 yearly. So that means each act is supported by the consideration. So what I have said, that consideration is something in return, is proved here. Next we come to essentials of a valid consideration, when we can say that the consideration given in the contract is a valid consideration. Among the essentials of a valid consideration, the first point is it must move at the desire of the promiser. The law says that the consideration must move at the desire of the promiser. If consideration moves at the desire of third party, it can never be a valid consideration. The consideration may be the desire of the promiser may be express or implied. But in case of the gracious services rendered by the promisee, this is not enforceable. Let's take an example. A sees that B is drowning and he saves the life of B. But in this case, as B has never told him to save his life, A has done this act graciously. So in this case, A can never demand any kind of consideration from B to save his life. But if B wants to give him something in return, it can be done. But this act without the desire of the promiser, as in case of this example, is not enforceable. But when a promise to subscribe to a charitable object is made, this is again unenforceable, but the remaining situation is that the other party has not taken any obligation on the basis of that promise. Let's discuss the case of Abdul Aziz versus Muzam Ali. What happened in this case? Mr. D has promised to Mr. P that he would pay rupees 500 for building a mosque. But later on, he did not pay any money. And in this case, Mr. P has sued that Mr. D has promised to pay rupees 500 for building of mosque, but now he is not paying that money. And in this case, the court said that as Mr. P has not taken any kind of obligation on the promise of Mr. D, he has not yet done anything on the basis of the promise given by Mr. D, so this act is again unenforceable. But if the other party, the promisee, has undertaken a liability on the faith of the promiser, then the act would definitely be enforceable. And this point is clear in case of the Kedarnath versus Gauri Muhammad. What happened in this case? D agreed to pay rupees 100 for the construction of town hall, and on that promise, Mr. P has taken some contracts. He has promised some obligations just on the faith of, just on the promise of the promiser that he is going to contribute rupees 100 for construction of town hall, and later on Mr. D denied to pay that money. In that case, what happened? Mr. P went to the court, and court said that because promisee has undertaken a liability on the faith of the promiser, so this act is enforceable. Mr. D is liable to pay to the promisee, that is Mr. P. The next point is the consideration must be real. If we want to make a valid consideration, the consideration must be real. Let's take an example. If somebody says, if you do something for me, I will match two parallel lines. As we all know, the parallel lines can never be matched. So this kind of consideration, which is totally impossible, which is not real, would not be counted as the valid consideration. Next point, it must move from the promisee or any other person. The third point, the third valid essential says that the consideration must move from the promisee or any other person, or any other person would be with the consent of the promisee only, at the desire of the promiser only. But in case of England, it only moves from promisee only. In India, this can move from the promisee or any other person at the desire of the promiser, but in England it moves only from promisee only, and this can be well explained in the case of Chinaya versus Ramaya. What happened in this case? An old lady gifted her all property to her daughter and said that in lieu of all that property, she has to give a certain sum of money to her maternal uncle, and the daughter also agreed for that. She also made the executions. She was also willing to do that, and she promised that she would give certain sum of money to her maternal uncle. But what happened later on? She denied to give any money. So in India, in this case, the uncle who is not a promiser, not a promisee, but can enforce the case. But in case of England, he would not be able to enforce that case. It means in India, the consideration may move from promisee or from any other person. Next point is the consideration must be lawful. The consideration which is given in the contract in lieu of some promise, that must be lawful. It is unlawful when it is forbidden by law. Any act which is forbidden by law, if it is being done as a consideration, it cannot be a lawful consideration. Is of such a nature, if permitted, it would defeat the provisions of law. If such kind of consideration is being given which is not permitted by provisions of law, let's take an example of the contract between two enemy countries, two aligned enemy countries. If such kind of contract is being made, such kind of consideration is being done which would defeat the provisions of law, it can never be the valid consideration. If the consideration is fraudulent, it is not lawful. If it involves injury to person or property of another, even then this consideration is not a lawful consideration. Let's take an example. If someone promises that I will kill Mr. A if B marries to C, right? There is a consideration which involves injury to another person. In that case, such kind of consideration is totally unlawful. This consideration would not be a valid consideration. Next is if the consideration is against the public policy. In case of smuggling contracts, in case of dacoity contracts, all these kind of considerations paid that are totally unlawful. That means if there is unlawful consideration, that would never be considered as a valid consideration. Next is the consideration may be past, present or future. But in English law, consideration should be present or future only. Let's take one example to explain the present, past and future consideration. For the past consideration, the consideration is paid in past and the act is to be done in future. That means consideration is paid before the act is being done. And in case of present consideration, the consideration and the act both are to be performed in present only. And in case of future, the act is being done now, but the consideration for that would be paid in future. So in India, three type of consideration is quite possible, that is past, present or future. But in case of English law, consideration can only be present or future. Next is consideration need not to be adequate. Yes, we agree that the consideration should be there, but the consideration need not to be adequate. Let's take an example. Mr. A has a car which is of worth rupees 5 lakh, but Mr. B is selling his car to his cousin for rupees 2 lakhs. That means the value of the consideration is far less than the actual value of the car. But now in that case, if the ownership of car is transferred to the cousin of Mr. A, in that case, the cousin has to pay rupees 2 lakh to Mr. A. That means there is a consideration and this is a valid consideration. Consideration may not be adequate. Means if consideration is being received less than the actual amount, this is even a valid consideration. But the consideration must be there. Next is it must be something which the promisor is not already bound to do. If the consideration is paid for those contracts, for those agreements where the promisor is already bound to do that, that is not a valid consideration. Let's discuss the example. A promised to pay money to police officer to investigate into crime. As we all know, the duty of the police officer is to investigate into the crimes. But if the police officer is being paid to do his duty, that means if Mr. A is paying two police officer to investigate into a crime, the agreement was considered to be invalid. As we all know, the officer was already bound to do that. He is not doing anything extra which is not the part of his duty. So that means if under consideration something is being paid to the promisor for which the promisor is already bound to do, that is not a valid consideration. Now we discuss the concept of stranger to consideration and stranger to contract. In India, the promisor or promisee or any other person can sue for the consideration. That means any other person except the promisee can also go for the consideration, but according to English law, the stranger to consideration can't sue the contract, as we have discussed in case of Chinnaya versus Ramaya. Now we come to the concept of stranger to contract. Any person who is not the party of contract, it would be known as stranger to contract. A stranger to contract cannot sue except in following cases. Means stranger to contract can sue for the consideration for the fulfillment of the promise, but except in few cases. We are going to discuss all those cases. First case is the trust. In case of trust, a stranger to contract can sue for it. Let's take an example. A gave his property to B, his son, in consideration that B would pay a village and a certain sum of money to C, who is a stranger to contract. He would pay to a certain sum of money and a village to C, the illegitimate son of Mr. A. In this case, if Mr. B denies to pay anything to Mr. C, who is an illegitimate son of Mr. A and a stranger to contract, in this case, Mr. C can sue for the property and that certain sum of money, as Mr. A has transferred his property to Mr. B on the trust that he would give a certain sum of money and a village to his illegitimate son. Second is when provision is made in marriage settlement. Third is when provision is made in a partition of a family. Let's take an example where a mother has two sons and both of the sons have agreed that they would pay a certain sum of money to her mother for his monthly maintenance. And here if one of the son don't pay, he denies to pay later on after the contract, and here the mother, who is a stranger to contract, can sue for that amount because the mother is a beneficiary in this account. That means where the provision is being made in the partition of a family, and then the stranger to contract, in my example, the mother can sue for that amount which was settled for her in a contract between two brothers. Next is where a charge is created in favor of stranger to contract on immovable property. Where the stranger to contract is a beneficiary in a contract of immovable property, in that case, stranger to contract can sue for that amount. Next, contracts entered into by agents. Where the contract is done by the agent and between the second party. Now, here the principal is stranger to contract, but because agent is working for his principal, they here if something wrong goes on in future, the stranger to contract, that means principal, can sue for the amount pending. Next we come to we come to the concept of no consideration, no contract. Normally we say that there must be some consideration when we make a contract. Without consideration there is no contract, the contract would not be a valid contract. But in few cases where there is no consideration, even then there is a contract. So we are going to read no consideration, no contract exceptions under section 25 of Indian Contract Act 1872. Among those exceptions, the first one is natural love and affection, section 25 subsection 1. Natural love and affection must be the case where something is being done because of just natural love and affection, but there must be some conditions which must be satisfied under section 25 subsection 1. First is the contract done was expressed in writing. First. Second, it is registered under law. Third is the contract was done or something was done on account of natural love and affection, and it was done between the parties standing in a near relation to each other. Let's say something. Let's define it by example. If father has done something for his son, so that means they have a very close relationship. If father has given his property to his son without the consideration, that means this contract is a valid contract because it is being done under the natural love and affection, but it must go for all the necessary things which I have mentioned here. Next is the compensation for service rendered. Suppose someone has done the services. Now if the person is being paid now for those services which he has already rendered voluntarily. The main thing here is the voluntarily. Then section 25 subsection 2 says that this contract is a valid contract even without the consideration, but with the few necessary things. One is the act must have done voluntarily. There was a legal obligation to do that. Promisor must agree now to compensate the promisee. Here the best example can be the founder of the lost goods. if some founder has found the lost goods, he has the legal obligation to return those goods to the actual owner, and he has done it voluntarily. But now if promisor wants to compensate that promisee on some gracious grounds, then it is perfectly a valid contract even without the consideration. Next is time bar debt. Time bar debt under section 25 subsection 3 are valid, but it must be in writing and it must be signed by the promisor. Next, completed gifts. If someone has gifted his or her property to the another person without something in return, this is totally a valid contract. Next is agency. As I have explained earlier, like if agent is working on the behalf of his principal, and if something is done on the behalf of principal on the gracious basis, this is called as a perfectly valid contract. Next, guarantee. If someone is giving guarantee for another without taking anything in return, even then this is a valid contract. And if somebody is accepting the less amount in lieu of the services rendered. Let's take an example. Mr. A has sold his mobile for rupees 1000, but in actual when he was receiving the money, he is receiving just rupees 800. He is remitting rupees 200, and this remission of 200 is without any consideration. Even then this is a valid contract. That means in these 7 cases, without the consideration, the contract can be a valid contract. So this is all about the consideration. We have covered 3 basic points till now. First 2 we have discussed in our previous lecture, that was offer and acceptance and legal relationship. And in this lecture we have covered the point, that is the consideration. Now we move to the 4th point, that is the capacity of parties. Section 11 of Indian Contract Act 1872 defines that every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. That means every person who enters into a contract must be capable of becoming a party of contract. Now what we mean by the capable, what we mean by the capacity of parties, every person who is entering into the contract may not be capable of doing that contract. Now who are the incompetent to contract, who can't make the contract? There are 3 number of those. One is the minor, second is the person of unsound mind, and third is persons disqualified by any law to which they are subject. Let's discuss them in detail. The first one is capacity of parties. The first person who is not capable of making a contract is a minor. According to Indian Majority Act 1875, minor is one who has not completed his or her 18th year of age. The Indian Contract Act says that any contract done with the minor who has not attained the 18th year of age, who has not completed the 18th year of age, the contract done by that person is void ab initio. Void ab initio, in other words, it's not a valid contract. Now what happens if somebody has done the contract with the minor person? The effect of minor's agreement. The first effect is that it is a void ab initio. Void ab initio means the contract done with the minor is totally void from the very initial. The court, the law never takes it as a valid contract, and this can be explained in case of Mohiri Bibi versus Dharmodas Ghosh. What happened? A was a minor. he has borrowed rupees 20,000 from B as a security. As a security, he has executed a mortgage in his favor. But later on, when he attained the age of majority, he said that he was minor at that time when he borrowed the money. So he should not return the money to Mr. B. And the court also said that when the contract was made, when the money was given to Mr. A, he was a minor. Now at this time, the money should not be returned to Mr. B. So that means even in this case, the court said that the contract done with Mr. A was void ab initio. This was totally void from the initial step. So this means the contract done with minor can never be said as a valid contract. Next is contracts beneficial to a minor can be enforced by minor. But yes, here the court gives the benefit to the minor that where in a contract the minor is a beneficiary, he can enforce that contract. In any condition, if the contract is being done between two persons, minor may not be the party of the contract, but if the minor is a beneficiary under that contract, he can enforce that contract. So in short, what we can conclude that the contract with minor is totally void ab initio. That means it's a void contract. It can never be considered as a valid contract. Now let's discuss the second point, no estoppel against minor. Where a minor by misrepresenting his age has induced someone to enter into a contract, he cannot be made liable on that contract. Reason being, this is the contract with minor is totally a void ab initio, as we have discussed in the previous point. It means that he's not stopped from pleading his infancy in case of contract. The contract may direct minor to restore the property if the minor has that property at the present. This can be done. Next, no liability in contract in case of torts. Even the court says that in case of torts, the minor cannot be held liable. Next is no rectification. The contract made by minor even cannot be rectified on attaining the age of majority. On attaining the age of majority. That means, let's take an example. If the minor has done any contract when he was minor, on the attaining the age of majority, if he says that now I will resign this contract, I will reside this contract, this provision is not given by the law. That means on attaining of majority, even a minor cannot rectify the contract. Because the reason behind it that when the contract was made, it was a void contract and the law does not allow to rectify the void agreements. Next is minor can be a promisee or beneficiary. If the minor is a promisee or beneficiary in any case, this can be enforced at law. This can be explained with the help of a case of General American Insurance Company Limited versus Madan Lal Sonulal. What happened in this case? A minor has insured his goods, but later on his goods got damaged due to some uncertainty. In that case, what happened? He has sued the company for claiming the price, claiming the insurance of goods, and the company took the plea that the person who has insured the goods was minor, and now the court says that as he was minor but he is a beneficiary in this case, so he can enforce and the amount for goods must be paid to the minor. That means where a minor is a promisee or beneficiary, he can enforce the case. Next, no specific performance except in certain cases. That means where the contract is being done with the minor, there the specific performance can't be demanded from the minor except in few cases. For example, only those cases can be enforced where there the minor is a beneficiary. No insolvency. That means a minor person can never be declared insolvent by the court because that cannot be the party of contract. Partnership. Under section 30 of Indian Partnership Act, minor can be admitted for benefits of partnership. That means he can never be admitted as partner, but the minor can be admitted into the partnership only for the benefits of partnership. Minor can be an agent. The minor can work for his principal as an agent, but the minor will not be liable to his principal. One. Second, minor can endorse negotiable instrument without himself being liable. In all these cases, the principal would be liable for all the acts done by the minor person who is the agent of the principal. That means minor can be appointed as an agent. Surety for a minor. Any person can give guarantee for a minor. That means he can be the surety for a minor. Next is minor as shareholder. Minor cannot be a shareholder directly, but he can be a shareholder through his lawful guardians. Minor cannot bind a parent on or guardian. If minor has done something, minor has purchased something, he cannot bind his parents, means his parents or guardians are not liable to pay anything to the other party with whom the minor has made the contract. Joint contract. Yes, in joint contract, minor can be a party, but the whole responsibility would lie on the person who is of the majority age. Next is liability for necessities. Where the minor has done something, where the minor has purchased something which are the necessities, there the minor can be enforceable. Minor is enforceable, but he is not liable of the price more than the value of the necessities. Let's take an example. If minor has purchased from shop various things, among those there are some necessaries and some are other things. In that case, minor can be enforceable only for the only for the value of the necessaries. But here again, no personal liability of minor is liable, but only his property is liable for the payment of the necessities. Next we come to the second part, second party who is incapable of making the contract, that is persons of unsound mind. Section 12 lays down that a person is aid to be of sound mind for the purpose of making a contract if at the time when he or she makes it, he is capable of understanding it and of forming a rational judgment as to its effect upon his interest. Which means court says that when a person makes a contract, he should be able to understand the terms, he should be able to understand the consequences of that contract. But if any person who is of unsound mind is not able to understand all the consequences of that particular contract, so he can never be considered as the capacity to enter into a contract. Unsoundness of mind may arise from idiocy, lunacy, drunkenness, hypnotism, or mental decay. Now, what are these terms? The first term is idiocy. Idiocy is called the absence of the mental development in which the person is incapable of understanding the complexities of a contract. So, in that case, the person is considered a person of unsound mind and the person is not able to enter into a contract. Second is lunacy. Lunacy is basically that is also called insane, in which the person has some brain disease, and due to that disease, the person is not able to understand the complexities and is considered as incapable of entering into a contract. Next is drunkenness. Drunkenness is basically a temporary incapacity of a person which creates impotency of mind, and in that duration and in that particular time period, when he is drunk, the person is considered as person of unsound mind. Next is hypnotism. Hypnotism is under the impact of artificial sleep, under which the person can't think what is right, what is wrong, and during that duration the person is not capable of entering into a contract. And last is a mental decay. With the passage of age, sometimes people don't understand the basics of contract, or they are not capable of doing the things so properly. So in that case, even though the persons are considered as persons of unsound mind, that means the court says that the Indian Contract Act 1872 says that when any person is of among these five, the person would be considered as of unsound mind and is not able to and is not capable to enter into a contract as party of contract. Next is persons disqualified by law to which they are subject. It refers to statutory disqualifications imposed on certain persons in respect of their capacity to contract. Means due to some statutory disqualifications, person can't enter into a contract, he can't be a party to contract. Among those, the first one is the aligned enemies. Let's take an example. If the two parties are from two different countries where there is a situation of war, where their countries are enemies, and if they want to enter into a contract, this would not be possible. They can't be the party of the contract. Next is the foreign souvenirs and minors. That again, where there is a foreign souvenirs and the court, the statutory there is a statutory disqualification upon those persons and they can't be the party of the contract. Then the insolvents declared by the court, they are the persons which can never which cannot be a party of the contract till they clear their status. Next, convicts. All the convicts while undergoing their imprisonment can't enter into a contract. They don't have a capacity to be a party of contract. Last is the corporation and companies, being they are the artificial persons. The corporations and the companies itself, they self can't enter into a contract. They work with their persons, they work with their managing team. Their managing team can enter into a contract, but a corporation and a company, being the artificial person, can't be the party to the contract. So these are all the persons who cannot be a party of contract. Among those, we have discussed minors, we have discussed the persons of unsound mind, and the persons disqualified by law. They can never be a party to contract. Now we move to the next point, which is essential for a valid contract, that is a free consent. Section 13 defines consent as two or more persons are said to be in consent when they agree upon the same thing in the same sense. Normally, when we say that consent means they are agreeing upon the same thing. But that consent must be a free consent. What we mean by the free consent? The parties to contract should only not have identity of mind, but the consent of parties must also be real and free. Means whenever any party of the contract says that yes, I am due to this contract, he must have the identity of mind, first thing, but that consent must be real. Section 14 says that consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, or the mistake. Means when any consent in the contract is given and which is caused by the coercion, undue influence, fraud, misrepresentation, and mistake, they can never be said that this is a free consent. Means in short, the consent should be on the with the identity of mind, as well as the consent should be real and free. Next, Now, as we have told that when the consent is under the influence of coercion, this is not a free consent. Now, what is a coercion? Coercion is a threat or force used by one party against another for compelling him to enter into an agreement. That means when one party, by using of threat, by using of force compels the others to enter into a contract, this is not a valid contract. Section 15 defines coercion as the committing or threatening to commit any act forbidden by Indian Penal Code or an unlawful detaining or threatening to detain any property to the prejudice of any person with the intention of inducing any person to enter into the agreement. It further covers acts forbidden by Indian Penal Code and unlawful detaining of property. Let's discuss them in detail. First is acts forbidden by the Indian Penal Code. All the acts which are forbidden by Indian Penal Code are covered under this. They are under the coercion. Let's discuss this with the case of Ranganayakama versus Alvar Sethi. What happened in this case? A young Hindu widow of 13 years of age who has just lost her husband was compelled to adopt a son under the threat of not removing the body of her husband for cremation. And at that time, she agreed to adopt a son. But later on, when it was sued, the court said that because she has given her consent under the coercion of not removing the body of her husband for cremation, so her consent was not free. So the adoption was not binding on her. If she don't want to have that, she is free of that adoption, which means anything which is against the Indian Penal Code and the contract made under this can be a voidable contract. Second, any contract where the consent is obtained at the point of pistol, there is a threat of imprisonment, there is a threat of committing suicide. If all these contracts are being done, this is against the Indian Penal Code and can never be considered as the valid contracts. Second is unlawful detaining of property. Unlawful detaining of property, for this we can discuss the case of Muthaiya Chetiyar versus Karoppan Chetty. What happened in this case? The agent refused to hand over books of accounts to the new agent till the principal released him from all the past liabilities. Here the agent said, till you release me from all the past liabilities, I would not hand over the accounts to a new agent. And here the principal agrees for that. That means his accounts were with the agent, so he have to agree here that he will release him from all the past liabilities. But later on, when he has not released and the agent sued for that, then the court said that because the consent given here was not a free consent, the consent was given because of there was an unlawful detaining of his property, his accounts. So in this case, this consent, this contract was not binding on the principal, as the consent given in this case was influenced by the coercion. And coercion may proceed from a stranger to contract too. Let's take an example. A said to B, if you don't marry me, I would kill C, who is a sister of B. That means if any person who is stranger to contract, if the coercion works there, even that is not binding upon the person who is making a contract, just because of that the person is under the threat, under the coercion. So under the coercion, any consent given, if any consent is given, that contract is never be a valid contract. Next component of free consent is undue influence. Now, what is undue influence? Section 16 provides that a contract is said to be induced by influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses the position to obtain an unfair advantage over the other. In other words, when the consent of the party to an agreement is obtained by undue influence, the contract so concluded is voidable. Means when one person is in a position to dominate the will of the other person, he is in a position to influence his or her consent. That means the consent is given under undue influence, and any contract made under undue influence is totally voidable, and voidable at the option of the party whether he wants to perform that contract or not later on. As per section 16 subsection 2, a person is deemed to be in a position to dominate the will of another. The person can dominate the will of another only in few exceptional cases. One is where he holds apparent authority over the other. For example, relationship between owner and servant, public officer and accused, etc. Means when the owner is there and he is in a position to dominate the will of the servant, because servant is totally binding, totally dependent upon his owner for his living. That means owner is in a position to dominate the will of servant, and under the undue influence of owner, if servant has done something, servant has given his consent, that means his consent cannot be considered as a free consent, and the contract would be voidable on the option of the servant whether he wants to perform it or not. Second, in case of fiduciary relationship. Fiduciary relationship, what is the fiduciary relationship? That means it is a relationship of mutual trust and confidence. Sometimes in the relation of trust and confidence, one has the power to dominate to will of the other persons. Like for example, the relationship of father and son. Father can convert the willingness of a son by using his mutual trust and confidence into that relationship. The father is in a position to dominate the will of his son. The relationship between doctor and patient, here the doctor is in a position to dominate the will of the patient. Similarly, the relationship of guardian and ward, that means where there is a fiduciary relationship, the one party has the capacity to dominate the will of the other party. Next, when where mental capacity of the party is affected due to age or illness. Sometime there are old persons. Let's take an example of a mother and a son. If a mother is of very old age, in that case, because of age, because of her illness, she has lost her mental capacity to think upon the things. So in that case, the other person, the son, the daughter, may have the position to dominate the will of that mother. So that means in all these cases where there the mental capacity of the party is influenced by the age or illness, in all those cases there the position of the one party is there which can dominate the will of the another party. So here we can't say that the contract is a the contract has a free consent. The third component under the free consent is a fraud. According to section 19, what is a fraud? Fraud means the misrepresentation of the fact with intention to deceive the other party. When one party is doing something and the intention is totally to deceive the other party, that means there is a component of fraud. According to section 17, what is the meaning of fraud? Fraud includes a false suggestion as to a fact known to be false, which in legal language is called as suggestio falsi. This is clear from the case of Peek versus Gurney. What are the facts of the case here? The prospectus of one company shows only the colorful pictures of their assets and does not disclose the liability part. and when the prospectus does not show the liability part, the general public thinks that the company has a very sound situation, the company has very sound position. So in that case, the investors has invested the company. Later on, when this is being revealed that company has high level of liabilities, and then the court said that because here the liabilities were not being shown in the prospectus intentionally, means the intention of the company was to deceive the other parties, that means this would be covered under the fraud. And if someone has given the consent to enter into a contract with the company on the basis of the information given in the prospectus, this is totally at the option of the other party to move into the contract or not to move. Second is active concealment of the fact, where someone has actively concealed the facts. There the consent by other person will be considered as the consent taken by the fraud. Let's take an example. A horse dealer sold a mare to B. A horse dealer sold a mare to B, knowing that mare had a cracked hoof, which he filled so that the other party cannot detect that. B later on discovered that that the mare had a cracked hoof, and this as a result agreement could be avoided by B. That means when the B had discovered that he was given the mare under the fraud, he can avoid the contract. That means the consent of the other party was taken under the fraud. The intention was to deceive. The first party always knows the facts, and the party is willingly the party is willfully misrepresenting or concealing the facts just with the intention to deceive the other party. So in all these cases, the consent can never be said that consent is a free consent. The promise made without any intention of performing it. When someone enters into a contract and he knows that he would not perform the contract in future, so this is again the case of fraud. For example, obtaining of goods with an intention not to pay for it. When the goods are being obtained, it was priorly known that I would not pay for those goods which I am taking it right now. That means this is a contract. There is a consent for the contract taken under the concept of fraud. Next है act or omission as the law specially declares to be fraudulent. Any act if it is being done which is under the law specially declares to be fraudulent, that is again the concept of fraud. Any other act fitted to deceive, means if some impersonalization is there to induce other party to enter into a contract just to deceive, with the intention to deceive, that is again under the fraud. And next is mere silence is not fraud. Normally we say that there is a caveat emptor. Caveat emptor means let the buyer beware. Sometimes the seller is selling the goods. Let's take an example. The seller has displayed the goods on a table. The customer comes and he inspects the goods. And after inspection, if he takes the goods and the seller knows that a few of things out of those table, out of the goods displayed on those table are not of good quality or are the damaged goods, he don't declare this, he don't speak even a word, he remains silent. This would not be counted as fraud under the principle of caveat emptor, as the principle of caveat emptor says that let the buyer beware. The buyer, when is inspecting the goods, he must take care the goods, he must see that if there are any damaged goods or something else is there. Next component is of misrepresentation. What is a misrepresentation? The word representation means a statement of fact made by one party to the other party before the contract. And a wrong representation is called a misrepresentation. Means before a contract, when a representation is made, then it is okay. But when the wrong representation is made, this is called the misrepresentation. Let's take an example. A intends to sell his horse to B and say, my horse is perfectly sound. A genuinely believes that horse to be sound, although he does not know that the horse has fallen ill yesterday. B thereupon buys the house. There is a misrepresentation on the part of A. Essentials for misrepresentation are: the misrepresentation must be of material facts. The misrepresentation given in the agreement, in the contract, must be of the material facts. If some misrepresentation is being done on some immaterial facts, this is totally immaterial for the contract, and contract cannot be resigned on the basis of this one. The misrepresentation must be false, but the person making it honestly believe it to be true. This is very important point, that the misrepresentation made on this part must be the false representation, and the person who is making the misrepresentation should make it honestly believe it to be true. Third point is, the misrepresentation must induce the other party to enter into a contract. The misrepresentation was made in the contract. The intention was just to induce the other party so that the other party can enter into the contract. If the misrepresentation is being done with some other intentions, this would not be counted as a misrepresentation. It must have been made by either by party himself or by his agent. This is again a very important point. The fact to the misrepresentation must be made by one of the parties or the agent of the principal, because agent works on the behalf of the principal. This is equally good. But when any misrepresentation is made by some third party, this would not be the on this basis the contract cannot be enforced. Let's take an example. Mr. A and B are making are the parties of the contract and are into the terms of contract, and when Mr. B asked about the quality of the goods, rather than Mr. A, Mr. C has given some misrepresentation. That means the party of the contract was Mr. A and Mr. B, and the misrepresentation is given by Mr. C. That means if the later on Mr. B found that there were some problem with the goods, and at the time of contract Mr. C has given the misrepresentation, and if now Mr. B wants to cancel the contract, he cannot cancel, as in this example the misrepresentation was made by Mr. C, the third party who was not a party of the contract. So on that basis this contract cannot be cancelled. So this is about the misrepresentation. Now we come to the last component of the free consent, that is the mistake. Now what is the mistake? The term mistake may be defined as incorrect belief about something. It takes place where the concerned parties are not fully aware of the terms of the agreement and they take the term in the different sense. Mistake may be of two types: mistake of law and mistake of fact. So what is the mistake of law? When something is done by mistake, but that is the mistake is just the misunderstanding of the law. This is called as mistake of law. This can be further of two types. One is mistake of general law of country, mistake of foreign law. The first point is mistake of general law of country. When the mistake is made regarding the law of the country, regarding the various provisions of the law of a country, this is called as mistake of general law of country. Country means the country of the parties involved. For example, if there are two parties involved into a contract, both are Indian. That means if contract is made under Indian Contract Act 1872 and any mistake is made in that contract, so that mistake should be that mistake of law should be against the Indian Contract Act. Next is mistake of foreign law. If some mistake is being made in understanding of the foreign law, so that would be considered here. Second is the mistake of fact. Mistake of fact may be of again two kinds. One is a bilateral mistake, second is a unilateral mistake. When the both of the parties have undergone the mistake, when the both parties are under mistake, that is called as bilateral mistake. When the one party has mistaken, when only the one party is mistaken and one party is doing his or her part rightly, this is called as unilateral mistake. Let's discuss the bilateral mistake and unilateral mistake in some detail. Bilateral mistake happens when the two parties are in the mistake, but the major thing is that should be a mistake of fact, not mistake of law. First thing. Second thing is the mistake must be regarding the formation of contract. Let's take an example. Mr. A was selling his watch to Mr. B for rupees 2000 and Mr. B thought that it is of 200. This is not a mistake. This is a mistake of one party. That is a unilateral. It is not a mistake of both the parties. This is when the both parties are mistaken, that is called as bilateral mistake. But when the mistake is on the part of a single party, as I have given the example, the watch was of 2000 but Mr. B was taking it as rupees 200. The mistake was on the part of Mr. B, not at the part of Mr. A. This type of mistake is called as unilateral mistake. This is a combined table which shows the effects of the various components of free consent when the consent is not free, when it is caused by coercion, undue influence, fraud, misrepresentation and mistake. We have discussed that when the consent is not given freely, it can has various effects on the forcibility of the contract. Let's see in the chart. In the first four components, coercion, undue influence, fraud and misrepresentation, the effect of four is the contract is voidable. Contract is voidable, that means it is at the option of the other party whether they want to continue the contract or they want to resign the contract. It is totally at the will of the party concerned. But when we talk about the fifth component, that is a mistake. In this case, the effect is that contract is void. That means any contract made with mistake, either the bilateral mistake or the unilateral mistake, or it is a mistake of law or mistake of fact, any kind of mistake, if present in the contract and the contract is made, the effect is only that the contract would be void, means this contract cannot be enforced. That means till now we have discussed the 5 components of the essentials of a valid contract. Let me revise it for you all. As discussed in the summary part also, in this chapter we have discussed the consideration, capacity of parties, under which we have discussed 3 major points: minor, persons of unsound mind and persons disqualified by law. And under the 5th point of free consent, we have discussed the 5 components, that is coercion, undue influence, fraud, misrepresentation and mistake. This is the end of this lecture. Thank you so much.